Welcome to Decoding the Conflict Mindset. This podcast is designed to help enhance, expand, develop your awareness about people in conflict. And so I invite guest speakers from all walks of life to share their insights and perspectives about just that, decoding the conflict mindset. Well, I'm absolutely delighted to have today our guest speaker, Harold Coleman. And Harold has been a colleague and collaborator for many years, and he was last on my show, almost 6 years ago. So I'm delighted to have him come back and share his pearls of wisdom and experience with all of you. Harold, he's got an incredible background. Harold has amassed over 30 productive years in dispute resolution as a civil litigator, arbitrator, mediator, ADR teacher, and much more. And he has tried, deliberated, and awarded hundreds of disputes of complex commercial and construction disputes. He was actually a civil engineer before he turned to law. And now he is the Senior Vice President of the Mediation Division for the American Arbitration Association. So he brings to us their mission, their objectives, and their service through training, education, technology, and of course service to the community, both private and publicly. Harold is somebody who has negotiated hundreds of complex, technical, again, commercial, and employment and probate matters in the role of AAA and Superior Court of California appointed mediator. I actually know him. We met first by doing a panel together on employment and mediation, so we share that passion. But he has so much more and brings to us so much insight. So, for the last 10 years, he's actually served, as I mentioned, with the AAA, American Arbitration Association, as a leader, and has been instrumental in bringing all kinds of new and novel programs to people just like you across the world. So stay tuned, pass this on, invite your friends and colleagues to come join us, because Harold is truly a gem with pearls of wisdom. I'm Dr. Deborah Dupree, the Mindset Doc. Our next episode is with Harold. Well, again, welcome to Decoding the Conflict Mindset. And here, as you know, we have Harold Coleman, esteemed colleague and Vice President of the Mediation Division for the American Arbitration Association. Harold, welcome.
Thank you, Deborah. So really great to be here as always with you. And I'm actually Senior Vice President, but I think that has more to do with my years of service in the profession and the fact that I am a seasoned citizen.
There we go. Well, thank you for the correction, because we do want to acknowledge people appropriately and accurately.
Excellent. It's
Great.
all good. Yeah.
Good. Well, Harold, we collaborate a lot, and I'm sure our viewers and listeners will learn more about that as we get into our program, our episode today. But one of the things that have brought us together, I know, is all about, the science, but the art of persuasion and use of emotional intelligence. And I find that people really like to hear the story. For those who know you, you've been an esteemed litigator and arbitrator, and now very active in the mediation world. And so I'm curious, for you to share with our viewers, just what was your journey in getting there?
Well, Deborah, it's interesting. Coming into arbitration mediation was not anything that I charted a path to do. I am a former civil engineer turned civil litigator, turned arbitrator and mediator, and teacher and trainer. When I was in the engineering field, I used to oversee projects from planning all the way through design, through bid and award, through construction, and through post-construction claims administration. And the higher I moved in project management, the more complex my projects were, the more I saw that my problems were either largely financial, or they were legal. Rarely did we have technical problems that we couldn't get our arms around, but financially, how to make sure the projects came in on time within budget. And then importantly, especially after the projects were completed, As you can imagine, they were just beset with a whole litany of claims brought by contractors and subcontractors against one another, brought against the owner. I was with a public agency, and we'd have to ferret these claims out. Brought against the design professionals for allegations of design omissions. So that's what then helped me to see in working with the lawyers who were responsible for trying to get these cases settled, or even responsible for the cases that went to litigation. It helped me to see how lawyers very rarely understood how projects go together. They didn't know how to read plans and specifications. They didn't really understand the life cycle of the project, of nomenclature, construction practices, et cetera. And I saw that as an area in which I could compete. So I went back to school, and upon earning my law degree and picking up my license, I practiced for many years with a firm in San Diego in the construction litigation, a real estate and construction litigation group. I was doing complex construction defect litigation. Some cases had as many as 20 parties to them. Very, very difficult projects or cases to get your arms around. The courts had a real hard time managing cases that large. So invariably, they would appoint what's called a special master, who at the right time would then convene the parties for mediation. And I get a chance to actually see much more action in mediation and to some extent arbitration than I ever did at trial, because these cases were too large to try. And that's how I whet my appetite on mediation and arbitration. I got onto the panel of the American Arbitration Association. I started to arbitrate cases. The firm I was with was totally in support of that. And then I got credentialed in mediation, and it's been a great, believe it or not now, 33 years ever since. And I've absolutely loved, not only just in the area of construction, but branching into other areas, commercial, employment, probate, done a wide variety of cases, not just for the American Arbitration Association, but also for the Superior Court of California and some of the local real estate boards too.
Well, yeah, it's always interesting, as you might recall, a couple, 2-3 years ago, I did an interview series of attorneys turning mediators, and not all were attorneys turning mediators. Some were human resource professionals, but it was interesting about usually some early experience, either in their childhood or in their life, that really triggered this passion. And bottom line, it was always about wanting to help people. And
Yes.
I think that gets lost sometimes as far as the helping people, shall we say.
Boy, does it ever, Deborah. I will tell you, as I have matured in the ADR field, and I always like to say that, of course, we have to be lifelong learners if we're going to be in the conflict management field. No one will ever be at the top of the curve where there's just nothing else to really learn. But I have become a student of psychology. I have learned that in the context of mediation, and even beyond mediation, conflict management in general, from conflict prevention to conflict containment to conflict resolution, I have learned that the real epicenter on which quality decisions turn have much more to do with human behavior than they do perhaps even the merits of the situation, the law and the facts, as we like to say as lawyers. And that has really helped me to adopt this one basic principle. And it's almost a bit of an ethos, if you will, that this process called mediation and conflict management in general is first, fundamentally, and foremost about people. It's not to say the law and the facts aren't important. They are. But in my judgment, they're not the most important. What's most important are the people involved, and where are they in this? Their needs, their concerns, their interests, their motivations. Where are they in the moment? Because if we keep in mind that is first, fundamentally, and foremost about people, what this calling is, we'll always do the next indicated right thing.
That's a really great point, because, if you didn't have the people, the laws and the facts wouldn't matter.
Yeah, that's
You know,
it.
I mean, we have to look at that, but if you didn't have the people, we wouldn't have these differences that need to be addressed for resolution.
Yes, exactly. And Deborah, I've done an awful lot of teaching and professional development training for lawyers. And one thing that I've noticed kind of gets everybody's attention. Sometimes you can just look out at the audience, you can tell, they had never heard this concept this way. And you can tell there are a bunch of aha moments occurring.
Mm-hmm.
And it's very simply this. What I share is that we should never, ever lose sight of the fact that every single legal dispute first begins as a human conflict.
Yeah.
So why don't we take it back to the human factors more than we do?
Mm-hmm.
Because if it really is just about the law and the facts, much of this could be algorithmic. It really can. I mean, we're seeing this with many of the studies that are being done now and the applications in AI. Artificial intelligence, to where computers can be programmed to deal with some highly subjective variables even, and then spit out certain indicators or values that will point to maybe a settlement range or a range of options. If it were really about the mechanical stuff, the law and the facts, to the extent that sometimes I think we as lawyers think it is, then this process could be much more algorithmic. You wouldn't have to bother the people. Okay. But it's the people who are the decision makers, and that's where I have seen, in many respects, the real hangups can occur unless we know how to navigate and really to work with them where they are as they are.
Yes, absolutely. So on that note, since you are senior vice president of the mediation division, we've talked about this, how it's sort of ironic, I guess, that the American Arbitration Association actually has a mediation division,
Yes.
And so what, from your perspective, and perhaps the definition by the AAA, the purpose, the objective, the focus, the mission of the mediation division, what is it that you're trying to accomplish in that arm of the larger organization?
Education, technology, and service. Education, technology, and service. All three of those terms are in our mission statement. We aim to provide really a quality assured education, not only to practitioners in the form of professional development training, but for the public at large on conflict management and the very nature of conflict and tools that one can use toward conflict avoidance on the one hand to conflict management on the other. As you well know, Deborah, we offer a wide variety of both basic and industry specific and advanced training to the practitioner world for aspiring mediators and for experienced mediators as well. So that's pretty much it. It starts with education, technology. We are very innovative in the use and in the embrace of technology as a very meaningful delivery platform for mediators. And that is attested to by mediation.org, which is our online innovation for the entire world of mediators and provides many tools for independent mediators. Our work in cybersecurity is another big area. Okay. Another area that I'm just now starting to get into, and we're going to take the association more into applications of AI, artificial intelligence, and settlement tools that can be used for parties to use directly before even needing third-party intervention in the form of a mediator. And then lastly, services. Party-centered, value-assured, value-enhanced conflict management services in the form of facilitated negotiation, which is what mediation is, conciliation, which is, what I like to say, is a deeper form of mediation because it focuses more on the people. Conciliation, shorthand for reconciliation. Dispute review boards, ombuds programs, peer feedback, peer evaluations, E&E, early neutral evaluation. It's interesting you mentioned that, American Arbitration Association, many may not appreciate that mediation though it's not in our name, it's in our DNA. We have been mediating cases since our founding in 1926 and have done hundreds of thousands of mediations, administered all types of mediations, including high volume caseloads, Superstorm Sandy, Hurricane Katrina, all kinds of really thousands and thousands of caseloads. So one of the things that's a passion for me is in ensuring that the services we offer are always cloaked and grounded and circumscribed by the model standards of conduct for mediators. You've heard me say this in various trainings, Deborah. We don't have to mediate perfectly. If we're honest and transparent, we never have and we never will. We need only mediate effectively and ethically. So it's the ethical practice of mediation, placing people first, people before the processes, people before the problem, people before the paper, people before the procedures. All of these things exist for people and their causes. The people don't exist for these other things. And that is something that we're singing loud and clear throughout all of our training, having it very, very well grounded in the ethical practice of mediation and conflict management.
No, I know we've had many conversations about this. And so there's two things. You said, what year did the AAA start?
1926
My
as
goodness.
the American Arbitration Association.
So almost 100 years coming up.
Yeah, in response to the enactment of the Uniform Arbitration Act, was now called the FAA, the Federal Arbitration Act. So we were the first out to, all right, you got this congressional legislation for arbitration. We need qualified people to deliver that service modality. And that's how we became the American Arbitration Association. I wish we had become, over time, the American Mediation and Arbitration Association, AMAA. But that's another story.
That's another story, yes. So I would like to have you describe an example of the community or the service part of it. How do you advance the concepts of mediation and arbitration into the communities so that they have a better understanding? Because this is often, this has been a conversation I've had for over 30 years, you've been at it for a long time. And, again, the public's awareness of the use of mediation as a tool instead of litigation continues to grow. But I'm still amazed that so many people, that I encounter really do not comprehend what mediation is and how it works. And so what would be an example of how you educate the community as a service?
Twofold, privately and publicly. Let me start with privately. Okay. The American Arbitration Association is the largest, the eldest, and the global dispute resolution leader. So our name is found in many, if not most, transactional documents. When parties come together in the construction field to build a structure, and the contract agreements between the builders and the subcontractors and the owners, et cetera. Or in the commercial setting, when parties form partnership agreements, they form they form any number of business transactions, they will have a dispute resolution provision that appoints the American Arbitration Association as the tribunal in case there are the problems arise. And very typically, there will be a two-step process: mediation first, followed by arbitration. And the vast majority of these kinds of contract provisions have that protocol: mediation followed by arbitration. So that's certain. We'll invoke the use of our 1,100-person mediation panel. And very typically, our rules will require that the parties mediate en route to arbitration hearings. So they occur on parallel tracks. So there's no slippage or time loss. Okay, we're going to bring the mediation to a total stop before then it gets scheduled for arbitration. No, they mediate en route to arbitration. The other is publicly, through a variety of public programs that we support, collaborate with, and fund. A good illustration of that would be, when we do, a great illustration is law enforcement, through our foundation. we have funded a number of worthy programs around the country to promote community building in the sense of law enforcement in the wake of the George Floyd and other debacles that have plagued society. So we've got those kinds of programs. We have public education. We have partnerships with organizations such as in SCMA, the Southern California Mediation Association, and what it does with various organizations. Kids Managing Conflict being another one of those. Just of a whole host of real rich, public-oriented, all not-for-profit or nonprofit, because we are nonprofit. None of these are in a profit-making mode. And to really, really sing home the reality that these processes of alternative dispute resolution have awfully high utility, not only for business, but for society in general and individually too, in terms of how the paradigm that we bring to conflict and how we go about navigating it and hopefully resolving it constructively rather than destructively.
No, amazing. I mean, it's pretty incredible as far as the reach that the AAA has, and I understand it's not just nationally; it's international as well. Yeah,
precisely. Through our ICDR, International Center for Dispute Resolution, which is our international division.
Right. And I've been honored to have been part of some of the delivery of training programs, so I know well about it. I'm curious, Harold, given your expertise, your longevity, your the range of and scope of your background, how has the legal market and the mindset shifted over the years of your exposure? From what you've seen, how has it shifted?
Well, first off, when I first started cutting my teeth, if you will, on mediation in right about the mid-90s, it was still in its inception. And you could tell in the legal community, I was litigating at the time. It was my full-time job. And I was part-time, as an adjunct with the support of my firm. I was doing ADR, arbitration mediation. And it was amazing how few lawyers, even back then, were like, well, why would I want to do this thing called mediation? Why would I ever do that? Why would I show my hand like that? Isn't that a sign of weakness? I just didn't understand it, And to see how far we've come in 20 to 25 years to where the courts have really gotten me all the way from the United States Supreme Court on to the lower courts, have so embraced mediation to the point of creating in almost every major metropolitan area court-connected mediation programs. Why? Because it works. 80% is a national statistic in terms of clearing court dockets, civil cases, getting them off the dockets, very, very high resolution rate. The big question is, are the parties serious and ready to mediate? Yeah. That's the best indicator as to how we know we can really make some serious progress. But to answer your question, that's been the biggest thing, to the point where, and this is really what's profound, Deborah, as you can imagine, I get an awful lot of metrics and data information across my desk from many different sources, public and private, institutional and organizational, worldwide. And mediation is now viewed, and this is coming from a study that the ABA did in right about 2015, and also our internal study we did, the association. Mediation is viewed by litigation counsel and corporate counsel, general counsel, as the alternative resolution vehicle of choice. Now, think about that for a second. The operative term, definite article D, the alternative dispute resolution of choice. Why is that? Because that's the one they're most familiar with. Because in litigated cases, chances are they are going to have to mediate before they get to trial. The court's going to make sure that happens. Even in the case of cases that have an arbitration proviso, still very typically will require mediation first. And even when it doesn't, parties have been sensitized and counsel have been sensitized to the high value of mediation. So that's been the greatest shift I've seen. Now, there's another shift I want to speak to very quickly, and it brings front and center the work that we're doing, Deborah, that you and I collaborate on. If I can tell a real quick story. one of the most profound moments I've ever had as a mediator is when I had an opportunity to co-mediate with a licensed psychologist who was appointed in a very, very contentious, high net worth couple were divorcing.
Mhm.
And the court appointed the psychologist mediator to mediate the relational issues, parenting plans, custody, all that kind of stuff. And the court appointed me to mediate the property division issues. Why? Because they had two businesses that had to be liquidated.
Wow.
So for me, it was like your regular general business mediation, but what I saw this was an opportunity for me to just simply observe and watch the psychologist do what he did.
Mhm.
And it was so profound. I realized I had to unlearn a lot of stuff that I had learned as a lawyer about mediation, and I had to become a lifelong student of human behavior and psychology,
Mhm.
because I really saw how radically different the behavioral scientist like yourself mediates than the lawyer mediator does. I mean, their
Mhm.
tolerance for risk, how they keep the onus where it belongs on the parties, and it's not their job to settle this, it is the party's job,
Yeah.
and how to really keep the onus where it belongs. So anyway, long story short is very simply this. I have seen now there is a much greater appreciation for my colleagues at the bar, okay, both who are advocates in mediation, litigators whose role is primarily that of advocacy, and for lawyer mediators themselves to realize the need for grappling with what every mediator needs to know about psychology, how to not be afraid of emotional content, but rather how to work with it in the context of mediation. And Deborah, I've seen this shift just in about the last 5 years. 10
Wow.
years on the high side,
Mhm.
but I think it's beginning to really pick up momentum in the last 5 years. And as you well know, we do a lot of training in this area in the soft skills,
Mhm.
because it's not just the hard skills that's necessary. Oftentimes, I find the real epicenter on which resolution turns is an appreciation for the soft skills, the people skills, the emotional intelligence necessary to mediate both effectively and ethically.
Yeah. You know, realizing that we've seen these shifts in just the last 5 or 10 years is really pretty remarkable. Because the notion of mediation goes back, centuries actually, with the
Yes.
village elders, and so that's basically
Right.
what we're doing. But now it's a professional practice, and so I'm curious. I know a lot of a lot of attorneys will bring their litigation strategies into the mediation room, not realizing that there's no room, there's not a place for that kind of strategy in a mediation room. And so how does expanding awareness of some of the people techniques, I'm not even going to call them soft skills here, the people techniques of how to communicate, how to, as I like to say, transform confrontations into conversations. How does that really help the legal professional in taking a different look, a shift in mindset, shall we say, to the people aspects of the dispute or conflict at hand?
Absolutely. And, let me just build on something you just said, Deborah, first, and kind of reframe something. I don't have a problem with the litigation strategy as long as it's grounded in ethics and an awareness of other parties' needs too, and how we can engage in joint problem solving for a common goal. I think the resolution of legal disputes probably will always require lawyering, and I have a very, very healthy respect for good lawyering. So I would take litigation strategy and just reframe that into adversarial posturing. See, the adversarial posturing is what's not helping.
Okay.
So what the litigator needs to do is really have a mindset shift on their very paradigm when it comes to negotiation. Yes, negotiation is a competitive process, but it need not be, nor can it be, exclusively competitive. It also requires a very, very large degree, healthy degree of cooperation if we are going to achieve a non-adjudicative outcome. Now, why is that? Because the reality is this. The only reason anyone will very typically pay a sum certain, say it's about money, the dispute, which most legal disputes are, pay a sum certain to get rid of a case at a particular time, and another party would accept that sum certain. And in both cases, they're not necessarily happy with that outcome, but they'll say yes to it. Why is that? Because they want to buy away the risk of a highly uncertain outcome, because you never know what a judge, a jury, an arbitrator, or a hearing officer is going to do.
Right.
So they want to buy away the risk of a highly uncertain outcome. So how do we maximize the opportunities for that to occur? It means that I have to, at some level, be willing to first appreciate what the other party's needs are, what their concerns are, and what the challenges are for them. And if I can figure out a way to try to address those while advancing my own needs and my own agenda, before you know it, we're into some genuine collaborative problem solving. And just think about that word for a second, Deborah. We hear so much about collaboration and collaboratives and come to mediation. We hope that you will collaborate. Co-laboring. That's at the root of this. Collaboration, co-laboring, not opposition working against one another. If that's all that counsel thinks that they think the mediation should be about, can be about, and who can pummel the other party into submission and maybe into oblivion, then I will very clearly tell them, you're in the wrong forum. You should rush to get your case heard at trial. You need to see if you can get your case on the fast track calendar and get to trial if you think it's that simple. And it can only be viewed that way, the way you're seeing it. You're in the wrong forum. You need an adjudicative outcome. And usually when I sing that message, you see they get sober and serious real fast. Yeah. So if this is a process that requires cooperation, and if I can help, people will tend, and we know this from Cialdini's principle of persuasion, reciprocation, people tend to reciprocate the behavior that's extended to them. If they see that I am genuinely interested in knowing what are your concerns, what do you really need in this, how can I try to help advance your interests? If you'll be willing to just reciprocate and listen, and let's just, or they're not talking past one another, and we can really, really make some things happen.
Yeah.
So that's how it has happened in my judgment.
Yeah, and thank you. Yeah, a lot of excellent points there. I'm curious. You shared a story. What's another example for how this shift in mindset? And I appreciate what you had to say as far as it's not so much litigation strategies, it's the adversarial approach that is distracting and obstructive to a mediated approach. And so what's an example of how this shift in mindset and skill set around emotional intelligence, around the 7 factors of persuasion by Cialdini, how does that actually help improve and enhance the negotiation process? What's an example of that?
An example of that is that it really humanizes the parties. Okay, it really does. Now, when you come to realize that every legal dispute first begins as a human conflict, and there's a real human being with needs, concerns, motivations, fears, etc. In a word, all these are subsumed into the term interests, with their own interests, that if I can demonstrate a little bit of empathy for what their interests are, which means I have to kind of learn what they are first, and by not being so quick to jump out there with advancing my own needs and my own agenda, but rather more curious questioning. Really the idea is to try to set the stage for having a learning conversation, out of which then hopefully some joint problem solving can occur. It's not about the argumentation, because they'll have an opportunity for that. Lawyers get plenty of time to opening arguments, closing arguments, all that stuff that goes on in the context of a trial or a hearing. There's a time and place for that later. Right now, we need to have a learning conversation so we can figure out a way to try to arrive at mutually acceptable outcomes. So let me give you a direct answer to your question in terms of this, something that seems so benign, but these little shifts can really influence how parties engage one another. You and I did a podcast on mediation, words matter, mediation and the language of lawyering, mediation and the language of lawyering. And what we espoused is that the words we use are powerful. They are used in a denotative sense, and words can be used in a connotative sense. And we really, our thesis was we need to reframe the language we use in mediation so that it doesn't parallel that and sound so much like the language that's used in the adversarial waters of litigation. Example, is it really, really facilitative of where we're trying to go if as mediator, every single time we're in a caucus with a party and we're referring to the other party, we're calling them your opponent, your adversary. The plaintiff said this, the defendant said that, or even counsel, referring to them as opposing counsel. I mean, how efficacious is that? And what I like to do is what I do in practice and what I espouse, hopefully I think is a sound practice, hopefully a best practice for others is just simply get to use people's names.
Yeah.
So Deborah, if you're counsel in a meeting, I mean, I'm not going to refer to you as opposing, well, Dr. Dupree thinks, or Deborah said, that type of thing. And you begin to humanize people. They see each other more as human beings and are better able to try to work together. So there's certain terminology that really should never enter into the mediation because it's so terribly polarizing and adversarial in nature. Be amazed, even little things like these aren't mediation hearings, as though somebody's going to get an order there. I want to see what the order is going to be if it's a hearing. No, it's a mediation conference. And these aren't proceedings and all that kind of formality. You'd be amazed how these things begin to really permeate the conscious and then into the subconscious, and people somehow just start working a little bit more cooperatively with one another. And that's just one technique. There are many others I could share.
Right. Yes, it is amazing how significant the impact is of words and how it can actually reinforce that oppositional perspective. We're still fighting each other rather than we're collaborating together. And so shifting our words and becoming aware of triggering words that only reinforce someone's position, elevates their fear, elevates their concerns about not getting what they want, and again, just opening their own mindset. And so words are powerful. Yeah. I guess.
Oh, you bet they are. Are they ever? Are they ever?
Yeah. So, when we talk about, I know we've talked just lightly about, these notions of emotional intelligence and the factors of persuasion and influence, to our listeners and viewers, particularly maybe for the seasoned ones who want to make some shifts in their life. I see that happening a lot, that people literally get tired of the litigation approach, but also for our up and coming who may feel compelled towards litigation but want to learn more about how to use the art of mediation more effectively. So, one or two tips that you might share with all of them or either population?
Yeah, I mean, I'm going to take a page out of Dr. Cialdini's book in terms of two in particular. Qualities. And this is whether a person is operating as mediator or as advocate, or maybe even a principal. First is reciprocation. To realize just how reciprocation is baked into our DNA as humans. In a civilized society, we tend to feel as though, if you do me a favor, I kind of owe you one in return. That kind of thing. And reciprocation. So that's so powerful at mediation. That if somebody is perceived as belittling or humiliating or insulting or taking a shot at someone else, high probability that they're going to respond in kind. And then, Newton's third law of motion, which is every action, there's an opposite and equal reaction. I guess it's the second law. And the problem here, though, is that opposite and equal reaction is never equal. It's going to be disproportionately higher. So now you have all the ingredients you need for thermonuclear war instead of a collaborative process. So reciprocation is huge. If people would just try to exude the kind and model the kind of behavior they would like reciprocated or done for them, to them, that does much to get this off on a positive note. And lawyers, I mean, inflammatory rhetoric during openings and mediation, they don't avail anything. They really don't. All they do is get the polarized. Save all that. And, if we're honest with ourselves, even in the context of arbitration or litigation in court, you can only go so far with, you got to tone that down even there because it turns off the jury. And I'm here to tell you as an arbitrator, it turns me off too. Can we be polite yet firm? Sure we can. Can we be direct and hard-hitting yet professional? Sure we can. Turn off the inflammatory stuff if you can. The other is a principle of liking. And this just goes back to Dale Carnegie 101, how to win friends and influence people. It's why I'm a huge fan of, we don't have to be artificial third parties in mediation. We refer to people by their name. If it's a company, to say, well, the folks over at Acme tend to feel, or we learn people's names and use it because it builds connections. And people tend to do business and tend to be much more willing to engage in a search for solutions with people they know, they like, and they trust. Right. So we can try to build trust and really leverage that principle of liking. Look for opportunities to share in a sincere way compliments, or do a positive affirmation. It's a great technique in mediation before you start telling the other party what it is that's bugging you. And heaven forbid, using that second person pronoun, you, and what they did. Build on something that starts off with a positive. Share something about the relationship that worked well and that you would love to see restored, and then go into what it is that concerns you. But when you start off with a positive affirmation, that is just absolutely huge. And the other thing, you've asked only one or two, but let me just share a third thing very quickly, and it's something, I guess I've been accused of a lot of creative thinking, but this one was distinctly my own. It's a saying that I actually have in the training. I have trainees just verbalize. They have to repeat after me. And it goes simply like this. Before I tell, I should ask. Before I talk, I should listen. Before I tell, I should ask. Before I talk, I should listen. So how do you engage in curious questioning and try to set the tone for a learning conversation? Don't start off with declarative statements about what you demand or need and what your view is. Start off with questions of the other party. Let's find out where they are. It actually gives you more reaction time too. So there's a lot of psychological benefit to that, but people will feel as though you're really interested then in hearing more about themselves and their needs. And therefore, guess what? Here, come back to Cialdini, reciprocation. They will tend to reciprocate. And when you see that happening, Dr. Dupree, you know the psychology behind it better than I. You are really, really off to some serious settlement building momentum. And the probability of mediation effectiveness goes way, way, way up.
And so, again, so many things that you've said, Harold, that I would like to capitalize on. But, in the interest of time for our listeners and viewers, and for the duration of this episode, we'll have to have you come back another time, or take one of our upcoming courses that will be, soon to be announced, and because we dive deeper into all of that. And I just can't emphasize enough, when I've seen advocates particularly make that transition into shifting their mindset and using language differently,
yes,
how much happier and healthier they are, as well as happier and healthier are the people that they're dealing with.
Oh, so true, Deborah, so true. And then again, we're bringing very high utility to society at large. And in the words of one of the former presidents, you know what? Somehow, some way, we need to become a kinder and gentler nation.
Yeah.
And I believe that to be true,
Mhm.
and think that it just makes problem solving all the less tenuous and arduous when we are.
Yeah. 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 So well said. So well said. Well, thank you, Harold, for again enlightening our viewers and listeners on decoding the conflict mindset, and not just those of our clients, but also our own mindsets and how we approach life, how we approach our practice, how we approach business, how we approach others, because shifting in small ways can produce tremendous results.
Absolutely. And thank you so much, Dr. Dupree, for the awesome work you're doing in the community, in the space of education. And again, the people first focus that I personally know you bring to this awesome, important, and consequential work we do called conflict management. Thank you.
Well, thank you. So here you have it, folks. The words and pearls of wisdom from Harold Coleman, experienced, significant, well-renowned mediator, arbitrator, and senior vice president of the AAA.
Senior, period. Right?
Yeah, senior, yeah. And so, I'll just share with you, Harold and I have a great deal of fun and learn a lot from each other by our many collaborations that we've done over the years, and we will continue to do in the future. So do keep us in mind and live, learn, and grow. That's what we have to do ahead of us, because our learning never stops.
Very well.
Thank you again. Decoding the Conflict Mindset, Dr. Deborah Dupree, the Mindset Doc. Don't go away. You'll hear a little bit more about our next guest speaker coming up. So thank you again, Harold. Love having you.
Thank you, Deborah. Thank you, everyone.
Well, I certainly hope that you enjoyed Harold Coleman. Harold, as I said in the beginning, we go back a long time, and I continue to learn, live, and grow with him. We've just had so much exciting time speaking and collaborating together. And what I've learned through him with his wealth of knowledge and vision, and all the way from a civil engineer to a lawyer, that analytical mind just baffles me. But anyway, I hope that you enjoyed it. Do pass it on. I invite him back every time I can. Now, a little bit of a shift, because we're going to take on a very important topic with our next guest speaker. I hear the word narcissism brought up all the time, and people going, oh, he's just a narcissist, or she's just a narcissist. Ooh, wait a minute, are you a psychologist? Are you really in the business of diagnosing people? We all have a little bit of self-centeredness. Of course, it may be more magnified in some than others. But what we're going to learn from Ina Johnson Myers is her own experience living the life with a narcissist and how to get out of that. And she's got a very compelling, powerful story. And not only has she done that, because we have more to come on this topic, in that she has put together an anthology of 12 stories of women facing similar situations like she has. And so please mark your calendar, subscribe now so you get notification of our next podcast coming up, Rising Above Narcissism with Ina Johnson Myers. You will want to tune into this one, and please pass it on. Let anybody you know who's dealt with behaviors associated with narcissism come and learn, because there's a lot to be shared. Dr. Deborah Dupree, the Mindset Doc, Decoding the Conflict Mindset. Subscribe now for future episodes. We'll be back in 2 weeks.